Good afternoon. My name is Michael Klass, and this is our July edition of our Planning Lunches at Noon or Planning Monthly Webinar Series. Today's discussion will focus on the meeting mechanics of local land use boards. I'd like to begin by introducing today's speakers. First, we have Christine Fillmore, an attorney at the law firm of Drud. Sorry, I'm just getting a note about the phone conference line. So I'm sorry if there's an IT on the call-in phase. I'll just note that we are going to record this and put it on YouTube. So apologies for any IT issues, as is the case. They seem to happen. And apologies for interrupting my introduction to Christine. She's an attorney at the law firm of Drummond Woodsum. Due to a last-minute conflict with our regular contributor on this topic, Sean Tangy, he's unavailable, and Christine has graciously offered to pinch hit at the last second. So thank you very much, Christine. And next, we have Tim Corwin. He's a senior planner and zoning administrator for the City of Lebanon. Tim's worked with Sean on this particular topic for several years for us and with us, and we very much appreciate his continued time and efforts. Finally, some of you may see new letters behind my name. As of July 1st, the Office of Strategic Initiatives has been disbanded, and we are now known as the Office of Planning and Development, and we are housed in the Department of Business and Economic Affairs. So our roles and responsibilities are the same. We're working through that transition now. It's going to take several months, and so we'll update folks as we know more and as it becomes available. Quick little roadmap here. We're going to be presenting in slightly different format as to some of our webinars that are sort of standard PowerPoint presentations. Due to the limited time and in an effort to sort of mix things up, we're going to be discussing these issues in a roundtable format. Our aim there is to focus on the discussion rather than sort of glossing over on slides. So we do know that handouts are valuable, especially after the fact. And so Tim was kind enough to revise his ongoing handout, and we'll make that available on our website on our training page after the fact. As far as a quick outline for today, we're going to first be identifying and then discussing several general goals that serve as drivers for sound meeting mechanics. Christine and Tim will then offer tips on what to do, how to improve your process, and potentially what to avoid. And then we will conclude with a question and answer session. I think first, the best place to start here is to take a step back and ask exactly what is meant by meeting mechanics. I see this issue as having two layers at least. There's a nuts and bolts layer, and that's really driven by the enabling statute, which governs, for example, establishing a board, notice, member terms, filing deadlines, etc. We're not really going to dive into those technical details today. For those, I'll refer you to the handout as well as the specific resources that our office provides for zoning boards and planning boards on our training website. And then you have what we're going to try to talk about today, which is a bit more amorphous. It's this discussion at maybe a higher level on why boards need to concern themselves with running a good meeting process-wise, and how to help improve this process. So that said, let's sort of review the overarching goals that I've identified today. First of all, we have this, what I think is the main one here is this fundamental fairness. And that's fairness for everybody involved. That's fairness not only obviously for the applicant, but equally obviously for abutters. I think for the board members themselves, you don't want to set yourself up to fail with a poor process for the board members, and also for the community. Obviously, the community has an interest in your land use regulations. So we want to make sure this process is fair at all levels. Second is improving the board's effectiveness. And effectiveness, what does that mean? I think that the way that I think of that is an effective board does its job with care and an efficient manner, and results that really end up in a fair, real, and realistically a pain-free process. If we have an easy application and there's no conflict there, you're probably not going to have any process issues. However, when you get that thorny application or that controversial application, that's really where any flaws in your process are going to be identified. You want to work the kinks out before you get to that point. That is somewhat related to the last one, which is sort of practical too. It's the legal defensibility of these things. regardless of if a board is issuing permits or denying an application, the process needs to be sound from the beginning to the end, such that you end up with a reasonable and lawful decision. And that's going to be generally the standard that the courts are going to look at if and when these things get appealed. So with those goals as our framework, I will now turn off the slides. I'm going to ask Christine and Tim for their thoughts. I'll start with Christine, and feel free to add any sort of introduction or comment thereof. And then I'd like your thoughts on what it means. So sort of when we talk about fundamental fairness and how a board can work to ensure that fairness.
Thanks, Mike. I think your introduction was fine. I don't feel the need to add anything. The reason that we talk about fundamental fairness is that land use regulation, virtually all aspects of land use regulation, involve a balance between the rights of people to own, use, and enjoy their property and the need for society to regulate how property is used. And those two things are always going to be, it's always a process of trying to balance those things. And property rights are one of the fundamental rights under both the New Hampshire Constitution and the federal Constitution. So everything that a land use board does, a planning board, a zoning board, involves somebody's right to do something with their property and the effect that that use might have on surrounding properties and the community. So as a result of that, both state and federal law include a lot of procedural protections and all of the layers of review that can happen for a land use board decision. And it all goes back to that idea that the process and the ultimate result for every application regarding land use should be fair and should preserve everybody's rights, the applicant's rights, the abutters' rights, the community's rights, everybody's rights. So Tim, maybe you want to talk a little bit about some of the procedural safeguards that implement that.
Sure. Thanks, Christine. So in order to sort of affect those fundamental procedural due process, there are certain safeguards that are written into our statutory scheme for land use board review. The most important of which, or at least the first of which, is to provide written notice of the proposed application or land use to immediate abutters, as well as some other parties that are identified in the statute: property owners, the applicant, abutters, easement holders. Those parties are given written notice of the hearing that identifies the date and time of the hearing and the place where that hearing is to be held. And so we want to make sure that there is notice at the outset to those who are most impacted by what the proposal is, so that they have an opportunity to attend the public hearing and participate in it. And again, that opportunity to be heard is really critical to ensuring that everyone's rights are protected as much as possible. That at the same time, that public hearing should be held in front of an impartial board. That's what we're striving for, so that we don't want any members who are conflicted or who are biased in any way to hear this matter and to weigh the applicant's request against any other interested parties' input or opposition. So we want an impartial board to hear these matters. It should be held in a public meeting that's accessible to the public. Increasingly, we see that these meetings are accessible to the public virtually, or at least in real time over CTV or something like that. But it should be an open and public process where all parties are given some type of opportunity to be heard. And then finally, we want a decision by the board that is understandable and based on the applicable criteria, and that's in writing, and so that everybody knows what happened and why. And so it's important to follow these minimum procedural safeguards to ensure that we're as much as possible sort of taking into account and protecting everyone's respective, property rights or interests in this matter. And I think we'll talk a little bit more in detail about some of those things later on. Christine, can you touch on the board's status as quasi judicial bodies?
I think you're muted, Christine.
Sorry about that.
Sorry.
It can be really helpful for boards to bear in mind that while they aren't technically judges, they are acting in a quasi-judicial capacity anytime that they are hearing and making a decision on an application or an appeal, depending on which board and what they're doing. But in all of those cases, the board is supposed to serve the same function essentially as a judge and the jury. The board is supposed to be impartial, as Tim said, just like a judge is supposed to be. The board is supposed to hear the evidence and the testimony and find what it thinks the facts are. And then it's supposed to take those facts based on that evidence and apply them to, or apply the law or the criteria for whatever it is they're doing. Say it's a variance. Apply the 5 variance criteria to the facts as you find them, and then make a decision. And so that's what a judge is going to be looking at later if it gets reviewed in court, where all of those things done. The one thing that's very different for a land use board than for a judge is that a land use board has to deliberate and make its decision in public. Everybody gets to hear what the board says and how they reach that decision. And there shouldn't be any mystery about that. That should all happen in front of people. So it's, and the rules of evidence are a little bit different. It's not quite as strict as court, but the idea is the same. And it all goes back to that concept of fundamental fairness, that everybody should have the same shot at having their rights adjudicated, and they should know why a board did what it did.
And I think
that gets into rules of procedure.
Yeah, I was going to say, so this is all, Tim's going to get into this in a second, but the rules of procedure are required in the statute. And I will just have an anecdote that oftentimes I'll receive calls from board members who I'll say, well, what do your rules say? And they say, oh, I don't know, I haven't looked at them. So that's right there. I would just put in an unsolicited reminder to review those rules. I'm sure Tim will get into this right now.
Yeah, no, that's a critical point. Thanks, Mike. Yeah, it's the rules of procedure are required for planning boards and zoning boards. All the statute says is that the rules have to identify or establish the method of conducting business, the board's method of conducting business. Other than that, the only specific requirement is that they need to address how alternates participate in the hearing, which is really important to figure out at the outset, and to make sure that your whatever procedure you've adopted for alternates is being used consistently. And again, that should be set forth in the rules of procedure. But back to Mike's point, it is very common that the rules of procedure are, not used, or maybe even some of the board members aren't even aware that they exist. But they're there. They should be there. They need to be there, and they're really important. And I think one of the points that we've made in the past, with this presentation, is the importance of really using those rules of procedure, and make sure that each board member, at least the chair, should really have those at hand while they're conducting the proceedings. It's as we've already mentioned, it's so important that there is in fact consistency between different hearings, across meetings, and that every application is treated, more or less the same. And it's very difficult to do that unless you're following a written procedure, because there's so much that's missing in the statute. There's so many things that aren't specified in the RSAs, and those gaps need to really be filled in by the rules of procedure. And if you do that and then you put them aside, you certainly, it's just becomes a whole lot easier to kind of review applications on sort of on the fly and on a case by case basis in terms of the procedures that that you're utilizing, or the extent that you're following the more formal structure that should be outlined in your rules of procedure. And so again, there's a couple points that we really emphasize in this presentation, and that is one of them. Like, get out your rules of procedure, and if you haven't looked at them in a while, it's probably time to update them. Make sure that what the rules say is what you're doing. And there's probably a middle ground. Your rules probably provide things that you absolutely should be doing and haven't been doing, or have been doing only inconsistently. On the other hand, there may be things that you've been doing more or less consistently that's in conflict with or not addressed by your rules procedure, and may be the better way. So it's time to update those rules one way or the other. So update them, use them, and obviously, run them by legal counsel, because, just like so many aspects of New Hampshire land use law, there are lots of nuances. There are a lot of holes in the law, and there's a lot of there's a lot of uncertainty. So you just want to make sure that your legal counsel takes a look at them, make sure that they're okay. There are certain things that really should be in there, like, again, alternates have to be, but the probably the most critical component, at least for the purposes of what we're discussing today, is how the hearing proceeds. And maybe that's modeled to a certain extent on maybe elements of Robert's rules are in there, or something else, but it should be clear, who speaks when, and at what time, and that should be spelled out as much as possible in the rules procedure. And then there are other things that maybe the statute provides a minimum, but you want to make those standards more provide a stricter standard. And there's a lot of uncertainty as to exactly how far you can go. And so it's important to work with your legal counsel, but update those rules, use them consistently, and don't let yourself, if you do that, then you're going to protect your board, the integrity of your board's process, and avoid unnecessary appealable issues in the form of a claim that you're treating different applicants differently.
I might also just add a point on that, which is that rules that are too complicated can be more harmful than helpful. Sometimes there are boards that have tried to take too much of Robert's rules, and they get all twisted around on whether it's a point of order or a point of information, and who can be allowed to make a motion to reconsider something you just did, and all of that. And if the rules are too complicated for an ordinary person to understand, if you have to look at them every time, they might be too complicated. Maybe it would be a little bit better if they were a little bit simpler, because the best rules are the ones that everyone understands and can use consistently.
Yeah, and I'll just add, yeah, I mean, when I think of these, I think that an outsider should be able to look at your rules of procedure and go to a meeting and have, after reading those rules, have an idea of how that process is going to proceed. And that way, right, you're sort of treating, an applicant can do that, or anybody to this equation sort of starts off at the same footing.
Yeah, and along those lines, make sure they're on your website. In a place that, in an intuitive place that's accessible. I've definitely run across, communities that they're buried. They're just, there's a hard copy in the planning office or in the, town hall or something. Make sure they're accessible.
So Tim, maybe you can, you referenced the conflicts of interest piece. Maybe
yeah.
You can back to that.
Yeah. So again, the goal here is to, ensure a process that that everyone has confidence in, as much as possible. So as much as possible, we want people, even if they're unhappy at the outcome, at least they can feel like they were heard, they were listened to, and that the decision was made based on, the applicable legal criteria, and not, something else, not on, whether the board members are personally in favor of the project or opposed to it. That it was a process and a decision that has integrity. And a key piece of this, as we've stated, is ensuring that there's an impartial board that's listening to this application. And of course, as I'm sure a lot of you know, these things become more difficult in a lot of New Hampshire communities that are smaller, and you know, everyone knows each other, and they have business relationships, and you know, their neighbors and things like that. But the idea is that it's relatively straightforward, and that is that and Mike, I know Mike has been working on this topic quite a bit, so I'll invite him to please, you know, add in, you know, jump in. But the concept is just that you need to come. Any board member needs to come to the hearing with an open mind. That's sort of step one. If you know, if you come to the hearing with an idea that you are going to vote one way or the other, whether it's to deny or to approve, and that nothing that's presented in the hearing will dissuade you from that you know, disposition, then you know that constitutes bias or prejudgment, and it's appropriate to recuse yourself. It's I would say it's human nature to have some idea of where you're headed. I don't think that can be avoided. You'll have, you know, hopefully you'll have the materials in advance, and hopefully you'll have reviewed those, and so you have an idea of what to ask at the hearing, and what it's all about. But again, if you've already decided, then you really, it would not be appropriate for you to sit on the hearing. That would you know, that would undermine the entire point of having the hearing, which is to gather evidence to inform the decision making. And so and that's okay. There, it doesn't, just because you're biased or you have some prejudgment doesn't make you a bad person. There's nothing. It's you know, if you're in a position where you're constantly prejudging an application, and finding that, you know, you're just so passionate about what's happening, you know, in your community one way or the other, that you just, you know, you immediately come to a decision, and you know, it's done. Well, then you're, you know, sitting on a zoning board or planning board might not be an appropriate way for you to contribute to your community. You could probably contribute in more effective ways. But as long as you come to the meeting with an open mind, willing to hear the evidence, and open to deciding one way or the other, then it's appropriate in general for you to sit on, you know, on that hearing. There are a couple of exceptions to that, where even if you are unbiased, even if you haven't prejudged the application, even if you are open to deciding one way or the other based on the testimony that's given at the hearing, there are still times when you just have, you're too close to the applicant or the project, and you just have to step aside again for the integrity of the process. And so some more common situations are where you're a direct abutter. If you're a direct abutter to the property, you're automatically disqualified. You need to step aside and let an alternate fill your role. If you have a pecuniary interest, if you have a monetary interest, if you stand to gain financially from this proposal, then that too is sort of automatic disqualification. I would say that, and this is a whole other lecture. This is a whole other 1 hour, if not 2 hour lecture that we could get into. But I would say that generally, if you have an open mind, you're not a direct abutter, and you don't have any, you know, direct monetary interest in the outcome, then it's okay to sit on the hearing, just generally speaking. But if there's any doubt, the best thing to do really is to at least state that at the outset. State that you have some sort of relationship, you know, to the application or the applicant, or you know, you're within certain proximity of the property. State that, and then you could either, and then how you handle it is sort of up to you, and a certain extent to the board and the chair. But you could ask for an advisory opinion from the board members. Do you think I should ask them? Do you think I should recuse myself? You could I think you can ask the applicant, do you have any concerns about that? Or maybe even, there's different ways you can handle it. I mean, of course, you want to try to be consistent, but you want to be as open as possible. If you do decide to recuse yourself, then leave the meeting. Just go to the, if you can leave the room entirely, that's preferable, but at least remove yourself and sit in the audience. Mike, did you have any thoughts on that?
Yeah, sorry, I was unmuting myself. The classic unmute, huh? So yeah, I mean, this is a really thorny issue, and like Tim said, this is there are reams of material on this. I guess I would just add a couple things. One is I think people have a really hard time sort of separating the capacities that they sit on the board. Just because some people want to take themselves off the board, but then they want to oppose a project. And I don't think that technically there's anything wrong with that. But if you ask your local municipal attorney, I'm guessing they're going to say err on the side of caution and just recuse yourself and don't be part of it. And that's because if you taint the process, you could impact the validity of the decision. And Christine can chime in on that if she wants, but you just have to realize that ultimately you have to make the call for yourself. The board doesn't get to, like Tim said, it's an advisory vote. So you can say, hey, does everybody think Mike should be kicked off this case? And they say, yeah. And I say, too bad, this is my call. You just have to realize that you could potentially impact the validity of the decision, and it's just probably not worth it. And the second piece that I have is just be wary of social media. That's sort of a new topic that folks are getting into. In some ways, it's just another venue for another forum for your speech. And so don't say anything on social media that you wouldn't say at the meeting. And just remember that whatever you say, can and will be used against you. So if you prejudge something online, that's the same thing as if you prejudge something at the meeting. So just be cautious of your social media use. Again, I personally would urge folks to sort of stay off social media if you're on the board and there's a pending matter. I think that's probably sound practice. But again, it's really up to you. So it is a tricky issue. So that said, I guess now we can sort of, we've sort of touched on what it means to be fair in a few minutes, and obviously we're sort of doing a high-level conversation on this. All of these points can really take up a lot more time, but let's move into a board, how it can be sort of effective and efficient in its process. And Tim, I think we're going to start with you on this one.
Thanks, Mike. I'm going to go over this very quickly because I see the time, and I think we're running short on that. So just the basic idea is that you want to get as much information to the board as possible, with as much advance notice as possible beforehand. You want to give, well, before that, you want to give the applicant as much information in as clear, as concise a manner as what needs to be submitted when, particularly in the form of checklists that summarize the submission requirements of your land use regulations, et cetera. Gather all that information, provide it to your board members as soon as possible. Prepare a staff memo if you have staff that may identify some issues or questions without any advocacy, and then make those available to the public, get those posted on the website, and make sure that everyone has as much time as possible to have as much information to digest, to understand the issues, to come to the meeting prepared, to discuss, ask questions, etc. And so I'm just going to leave it at that, and then punt it over to Christine for our next topic.
Sure. So there are different players that can be involved in a community that is lucky enough to have staff. I would urge the board to use the staff. Make the greatest use of your staff that you can. To do all of the things that Tim just talked about, getting people prepared for the meeting. Although every board member really needs to have a firm commitment to being prepared for being at the meeting. As far as the board members go, the chair is really the key to a successful, efficient, and effective meeting, I think. A chair needs to do a lot of different things. They need to have a really good understanding of the rules of procedure. and a fairly good outline in their head about what the key issues are that the board needs to look at. Again, preparation is key there. The board also needs to be the chair needs to be really firm in the control of the meeting, not like a dictator, but, firm and understanding. So if there's a process, you have the procedure, who's going to speak first, who's going to speak next, one person's going to speak at a time. People are going to present their comments or their questions through the chair instead of having side conversations and interrogating one another. All of those things are things that the chair needs to control firmly. And one of the best ways for them to do that is at the beginning of a meeting and then at the beginning of a hearing within a meeting to say, this is what we're going to do now. And here's how the procedure is going to work. And this is when everybody will get their chance to talk. And then when someone interrupts, the chair can very firmly say, I explained before, this is when you're going to get your chance to talk. But you can cut most of that short ahead of time if people get the idea. Because what I have seen is that people are very passionate and excited to talk, and they're worried that they're not going to get their chance, and they're just going to continue to be worried about it, and it's going to get worse unless they know right up front when their chance is. So that's really important. It's also key for the chair to have a good relationship, a working relationship, and trust in the staff, because the staff is going to be the person putting together the material, getting everything ready. Also, you need a good relationship with the person who is preparing the minutes, so that that person feels comfortable in saying, hey, could you repeat that or slow down or spell that or whatever? Because as we're going to talk about in a little bit, the record is extremely important in land use hearings. So the minutes need to reflect all of the important pieces of information, and that person needs to feel comfortable saying, one person at a time, I didn't hear that, whatever it is. And then there's legal counsel, who may or may not be present at your meeting, but when they are, that's a useful resource as well that can also provide support for the chair and for staff. One thing that I think sometimes happens inadvertently is staff generally has a large amount of knowledge about things, but they should avoid giving legal advice. They may have legal advice that they have received, and that's a whole different topic. But it's really useful for the board and the staff to understand that the staff is there as a resource. They can provide information and documents and all of that during the hearing. What was that document? When did we get that? Do we have this? So all of those things can work together to make it flow better and so that the information is available. One other issue, if there are specific issues that are related to the application, but that this board, whatever it is, doesn't have any control over, it's really important for the staff and the chair to understand those things. So for instance, if there's a driveway permit needed from the state on a state road, or a septic approval, or a liquor license, or if there are facts that are relevant, issues that are relevant to a subdivision, but the ZBA is looking at a special exception for the use, there may be different factors, and it's important for the chair to have an idea of which things this board is not looking at right now. First of all, so they can say that to people when the irrelevant things come up. And also so that they can say, that is something you need to take up with the planning board. It will be relevant then. Or it came up actually very recently, there are uses that are very controversial. And an ordinance may say, this use, say short-term rental, is allowed by special exception. Here are the criteria. So when the ZBA is having a hearing on that, that is not the time to talk about the policy decision of whether short-term rentals should be allowed at all. So voluminous material about how bad they are is not technically relevant, although extremely relevant at town meeting time when you might want to be amending your zoning ordinance. But for a zoning board, they would need to stick to the criteria for the special exception. So those are general outlines of things that the chair can go a long way toward making the meeting more efficient and effective if they pay attention to them up front.
Thanks, Christine. So we've sort of talked about the fairness piece. We've talked about how to sort of move these meetings along in an efficient and effective manner. And there's sort of a practical aspect here, which is defending them in court when the inevitable appeal comes. So Christine, maybe you can talk about how mechanics can potentially impact the sort of underlying legality of a decision.
Yes. And the legality of the decision is going to be looked at by a court, again, through the framework of fundamental fairness. Are we being fair to all of the parties? And was the process fair to everyone? Is the decision fair in that it is based on the facts and the evidence and it applies the correct legal standards? Appeals are not bad in general. That's another important thing. They happen. Parties have a right to appeal. Anybody who doesn't like the decision, who has standing, can appeal it. So the fact that there may be an appeal shouldn't automatically be scary. Simply being prepared for it is every single time is the way to deal with it. Some appeals will have to do with, what does your ordinance mean? There's a term, it's not defined. What does it mean? That can be 50-50. It depends on which judge you get and what day it is and how they're feeling about it. Our goal is to make sure that the process is fair all the time for everyone. And if that is accomplished, the board has done a great job. So some of the specific things that can affect that are the idea of when the hearing is over and the deliberations begin. While a hearing is going on, that is the chance for everybody to say what they think. For the applicant and the abutters and everybody else, that is also the chance for the board to ask questions of all of the parties. Everything the board wants to know should be asked before the hearing ends, because when the hearing ends, and the chair should be very clear about, I am now closing the public hearing. This means that public participation is over. We will not be accepting any more evidence or information or documents or comments. And that should be reflected in the minutes so that everybody knows when the hammer comes down on the hearing and the deliberation begins. And deliberation is the point at which only the board members get to talk. They don't get to ask questions of the applicant anymore. They can ask staff members for, information and documents and pointers, help me find out, did we get this, did we get that? But really what deliberation is supposed to be is the board looking at all of the evidence, thinking about it, arguing about it, seeing, did the applicant meet the standards that they need to in order to get the approval or the relief or whatever it is that they're asking for. That can get a little bit messy sometimes if you're not particularly clear about when the hearing ends. There are very, very narrow circumstances in which you might want to reopen a hearing, but I would say don't unless you've talked with your legal counsel and they've tutored you on how to do that properly. For instance, has anybody left the room? If anyone has left the room after you close the hearing, don't reopen it. Renotice, start again another night, continue it to another night. So that's one thing, and that needs to be reflected in the minutes. And then what happens during the deliberations is really important. All of the members of the board should talk during deliberations, because the goal is for people to look at your decision later, read the minutes of your deliberation, and be able to understand why the board did what it did. Were all of the factors or criteria or specific issues that apply to this application, were each one discussed? They should be. Did the board go through the evidence that's relevant to each of those things? They should. And is this discussion in the minutes? What I cannot use to defend a decision is a set of minutes that says the board discussed, and then there's a motion and a vote. It should be much, much, much more than that. It doesn't need to be verbatim, but this is a place where minute taking is extremely important. And I might add that if a board does not currently use an audio recording to prepare its minutes, I highly suggest that you start doing that. Because that makes it much easier to go back and capture all of this, all of the discussion. So as I said, at the end, everybody should be able to understand why the board did what it did. And that includes not just was it approved or denied, but why was it denied? Exactly why? Which evidence was important? Are there conditions? What are they? They should be spelled out extremely clearly, because the decision is being made for a bunch of different people who aren't in the room today. It's for the applicant and the person the applicant sells their property to. It's for the judge in an appeal. It's for the land use administrator 5 years from now who's looking at, or code enforcement, who's looking at whether anything is being violated. And that leads me to the record on appeal. So when there's an appeal, either to court or the Housing Appeals Board, they generally are not going to have witness testimony and new documents. What they're going to get is the record from what happened at your board. And if it's a ZBA decision on an appeal from some other board, what happened before that board? So that is the minutes and the application and any documents that anybody involved submitted, correspondence back and forth between the applicants and the town, or abutters and the town, all of your notices, all of those things. Your written decision with the reasons, the whole file goes to whoever is hearing the appeal. And that will be prepared by your land use staff if you are fortunate enough to have land use staff. So when if your lawyer is looking at the record, that's what they have to defend your decision with. And they will need to point to information that's contained in the record that the board had before it to support the decision that it made and show that there was evidence and they did apply the legal standards that are relevant to that application. If that stuff isn't in there, it's going to be really difficult to get a judge to uphold the decision. And there are two negative results you could get here. One is the judge says, I don't know what you did, and we'll kick it back. It will be remanded to the board and they'll have to try again. That's a giant waste of everybody's time and money if you can avoid that by having a good record. The other big scary thing that can happen is a judge can say, well, I'm not really sure why they did what they did, but I see information in this record that's enough for me to say the board should have granted this. Absolutely. So I'm going to just say they can do it. I'm going to grant, it's called a builder's remedy. And that means that the applicant gets their permit exactly as they asked for it, perhaps with no conditions on it. And the board does not get to try again. So that's, I think, the ultimate bad result you might get. So with those things in mind, as I said, appeals aren't necessarily a bad thing so long as you have done the work ahead of time to make sure that there's a record that supports your decision.
Yeah, that's interesting. I never really thought about, like you said, you never know what a judge is going to say. That's sort of out of your control. But for this mechanical pieces, that is all within your control. And that's all, hopefully things that won't, result in a decision against the board. So, so certainly the legality piece is intimately connected with media mechanics. So now we're gonna take a couple minutes and just do, we're at 12:43. I think we're gonna try to do 10 or 15 minutes of questions, and there's 8 or 10 questions already on the chat. So maybe real quick, Christine and Tim, you can sort of give us your top tip or two on what you think, how to improve mechanics, and also what to look out for.
Okay. So I think creating an environment that makes everyone feel comfortable that there is a process, it will be followed properly. And that, again, starts with the chair. The chair needs to be firm and patient and understanding with people who are confused or nervous. This might be the biggest thing that has ever come up in their lives, and you're in charge of it. So whatever a chair can do to make people feel like we have it under control and we're going to be fair and we're going to proceed accordingly, and everyone is going to get a chance to talk and maybe explain things more than once when people forget the rules or they just start shouting things out. Really, the chair can set the tone for that right from the start and all the way through. And if people feel heard, as Tim said earlier, that can go so far toward helping the process work better. And I think my top don't do would be, don't be rushed into making a bad decision. You are always holding someone up on a board. Developer always wants their approval yesterday. That doesn't mean you have to give them their decision the night that the hearing starts. If you need more information, take time and get more information. If you need to talk to your lawyer, take time and talk to your lawyer. There are some outside deadlines that you do need to keep an eye on, but don't get rushed into making a decision before you're ready. Tim?
Thanks, Christine. Just a couple miscellaneous things to avoid. Again, it can't be emphasized enough that the public hearing is the time to ask questions and obtain information, and the chair, prior to closing that public hearing, should ask each board member or ask the board, are you sure you have everything that you need? Are you sure you have all the questions answered? And then once that's closed, it really is a discussion among board members. I agree that staff can be asked, very technical questions, but I think even questions to staff should be limited, and you really should try to ask those if possible before the public hearing is closed. What we really want to avoid and what we see so often are these call outs during deliberation. Hey, Joe, what did you say about that? Or Joe, are you okay if we add that condition? That's really inappropriate and undermines the credibility and integrity of the whole process. Even if it seems very comfortable to do that. The other thing is during deliberation, participation of alternates. It should be very clear whether or not, I would say whether or not a voting member can participate or not in that deliberation. That should be known at the outset, probably specifically discussed in your rules of procedure. And then just two other things. Again, be prepared. As much as possible, make sure that you read at least once whatever is given to you before the meeting. If you have a question, and that can be, it's a technical question maybe that can be answered by staff, contact staff rather than use the time during the meeting to ask that question that could have been asked and answered beforehand. Do so. Don't wait to the meeting and take up the board's very limited time. And finally, don't abstain. Don't abstain from a decision relating to a land use board application. It's your job. If you find it difficult to make a decision, that's your job. You still have to do it. So no abstentions from waiver request or completeness or the final decision. You need to be there and you need to just make a decision, even if it's a really tough one.
That's good, Tim. I don't think that people really think about that. It's an easy out and it doesn't really help anybody. So that's great. I appreciate it. And it looks like we are about, I will just note, just remember that the right to know law does apply to boards. And sometimes, we're really focused in the enabling statutes and our rules of procedure, which we're all going to go home and review tonight, and so on and so forth. But just remember that this is a public process. So you need to be aware of, accidentally convening a quorum via email. Again, like the conflicts of interests, the topic 91A, the right to know, it's its own separate webinar or presentation. NHMA does a great job on this, so I'd refer you to that. But just remember that applies, because sometimes it kind of slips through the cracks. So that said, it is time for questions and answers. So it looks like we have, I'm just going to get started here. We're going to start from the beginning, and let's see. Are changes to the rules of procedure something that can just be changed by the planning board at a regular meeting? So maybe Christine, how do you advise folks change or revise these rules?
First of all, look at your rules and see if you have a rule about that. Maybe you do, maybe you don't. If you have a rule, follow it. The law just says that boards have to have rules of procedure. But since boards are, they have to follow RSA 91A, they can only change their rules by a vote that they take at a public meeting. The mechanics of how you do that is up to each individual board. Some boards require, you have to introduce it at one meeting and you can't vote on it until the next one. That's all up to you. But yes, the rules can be changed by that board at a public meeting. They should be changed so that they apply prospectively. So you vote to change your rules of procedure and be clear that that's not going to take effect until your next meeting. Or, when are those rules going to take effect? Because getting back to fundamental fairness, everybody has a right to understand what the process is and what the rules are that are going to govern what's going to happen. There's one very specific legal issue about that, which is a ZBA that changes the way that it votes on variances. Is it going to vote on each of the 5 criteria separately or one up-down vote? If you make that change in your rules of procedure, it does not take effect until 60 days from after the date of your vote, and it doesn't apply to any applications pending at the time that you vote to change that rule. But otherwise, just bear in mind that everybody should know how it's going to work ahead of time. So don't change the rules that night and then say, and now we've changed our rules and you don't comply.
Yeah. And that actually, so the ZBA voting relates to another question. So we're going to skip ahead a little bit. There's another question asking a question which we've received a lot, which is, should the ZBA be voting on each of the criteria or all at the end? And I think the answer is it depends. Like Christine said, you just have to put it in your rules, and it's not applicable for what, 60 days after?
I think it's 60. I'm looking it up right now, just to be sure.
Okay. And I guess, do either of you have a sense on what boards are doing more?
I don't have a sense of that. I know that Sean Tanguy, who normally gives this presentation, his feeling is that his recommendation is that the board speak about each criteria individually, and I think vote on each criteria individually. I don't know that I 100% agree with that. I definitely think that, I mean, the law requires consistency, but I think it's critical, absolutely critical, that each criteria is specifically discussed and addressed, and that discussion is reflected, hopefully in the written decision, if not at least in the meeting minutes. But I'm not sure about the voting on each criteria. But however you do it, it just needs to be consistent.
It is 60 days on that rule that it takes for the change to take effect. And I see it going both ways. I'd say it's probably about 50-50 right now among the boards that I work with. And there are pluses and minuses to both of those ways. If you vote on all 5 at once, you know what the vote is. But if that happens, the motion needs to be really clear about exactly what the motion is. If it's a vote to deny, it has to be, I move to deny the variance because they don't satisfy this because of this, and that because of that, rather than I vote to deny. You need to know why. The downside to voting on each one separately is that if you have 5 ZBA members, a different ZBA member thinks that
Right.
each one of them has not been met. So in the end, you've got 4 yes, 1 no on each of the 5 criteria, but nobody believes that they've all been met. So
Right.
should it be granted? I don't know.
That's
it's a
my
math
problem.
and it gives me a headache. But legally speaking, either way goes, as long as your minutes reflect why the decision was made, exactly which ones were satisfied and which ones weren't, and why.
Great, thanks. Sort of speaking of ZBA votes, and this gets to the transition from public meeting to deliberations. The question is does a vote need to be taken to move from, to close your public comment? Or can the chair just close it and then move into deliberations? And then, or does it vary between town to town?
Varies between town to town. Some boards have a rule that says we're going to vote to close the hearing, and some boards don't. And it doesn't really matter, legally speaking. What should happen from a fairness perspective is that the chair should ask repeatedly, does the board have any more questions? We've now heard from the applicant and the abutters. We've heard from people in support and opposition. We've heard rebuttals from all of those. I often suggest that you give the applicant the last word because they're the one who has to satisfy whatever the standard is. Not every board does that, and that's okay. But the chair should, if they are not taking a vote, and actually even if they are, before the chair calls for a vote to end the public hearing, ask and ask and ask again. This is your last chance to talk. Do you have anything else to say?
And obviously that should be baked within the minutes because it doesn't really do much good if it's not memorialized in the record. So the next question
in the record, it might as well not have happened.
So Tim, I'm going to kick this next one to you. So this question is about would like a clear definition of what can be reviewed at a conceptual review or design review. I know that a design review requires public notice, but a conceptual can occur at a regular meeting, but we are limited to what we can discuss or review as far as plans go. So this kind of gets into the substance of a planning board, but maybe mechanically speaking, do you have any suggestions for that distinction?
Distinction between conceptual and design review?
Yeah, just in terms of how far can you go without notice?
That's a good question. I haven't considered that. At the conceptual review, I think it's the conceptual review does not require notice. It's a free-flowing discussion. It's non-binding. I think anything goes, and so I'm not sure. I mean, if if the board is making some sort of, is taking a vote, which they shouldn't be doing, if they're making some sort of definitive decision, well then, yeah, that's becomes something else. But as long as it can be a wide-ranging, free-flowing conversation, as long as nobody's making any decisions about anything, whether formally or informally, then it doesn't become something else. It doesn't transform from a conceptual review to something else. I think it seems to me that the clear line is, was a decision made, whether it was sort of informal or formal, and I think the same really applies to design review. Design review does require that notice, and it's important because it relates to the vesting of an application and which set of regulations apply to that proposal. But even there, it's kind of just a heightened conceptual review. It's a free-flowing conversation, totally non-binding. Nobody's committing to anything, and to the extent that the board is committing itself to something, then it's no longer design review, and it becomes something else, and you should consult your legal counsel.
Great. Next question talks about conflicts. It's, if you're recusing yourself from a case as a direct abutter, is it appropriate to speak in favor or against? And again, I think we got, touched on this briefly. You still have your constitutional rights. I don't think there's anything preventing you from doing it. Just be very cautious, because there could be arguments made that you were somehow, tainting that process, through your relationship on the board.
I usually say, be careful to preface all of your comments in that case with, I am speaking for myself as an abutter. I am not speaking as a member of the board.
Maybe literally get two hats and put the private hat on. So next question is, so to what extent do errors in the public notice require new notice? And I know sometimes this comes when the notice goes out and it's slightly different than what an applicant is actually asking for. So maybe, I don't know which one of you wants to touch on that one.
If it's really wrong, do it again. If it says special exception and it's a variance, do it again. If it has the wrong property listed, do it again. If it says, if the date is wrong, I mean, really the issue here is it going to give someone a meaningful notice about what is going to happen and when it's going to happen, so that they can be there if they want to be. If they had known, would they have shown up? I think is the question. My general answer, though, is if you're worried at all about the notice being incorrect, do it again, because nobody wants to have to go through the whole thing again.
And it's a lot cheaper for the town to pay for new, certified mailers than it is to call Christine up and have her figure out what's going on. So we are running a bit out of time. What I'm going to do is, and I want to honor the lunch hour. So there's some remaining questions, and I'm going to try to tackle those offline as best I can. And if I need to reach out to Tim and Christine, I'm going to do so. And I'm going to share one last slide here as we say our goodbyes. Apologies for firing this thing up. All right, so you know what? I'm just going to skip this. on the slides that are going to be posted on our website will be our contact information. That information it's going to be for all three of us. Excuse me, I'm just finding my place here. Please, if you contact Tim or Christine, if you can please make sure to put a little caveat in the subject that this has to do with the planning webinar, so that they know that this is not part of their regular 9 to 5 job, even though it's probably not 9 to 5, and they can triage it appropriately. I also urge you to reach out to me. This is part of my job, is to sort of help with these questions. And with that, I will thank Tim and Christine very much for their time and attention today. And I will also thank you all for your participation. I think we've had pretty good participation on these. And this is another one. There was 60 or 70 folks online today. So that said, I appreciate everybody's time, and we'll bid you adieu. Thank you.
Thank you.